Alrighty, everyone. So we'll go ahead and get started. I just want to first start off with saying thank you for joining us today for our kickstart of our IP webinar series. The first one today is going to be on trademark basics for inventors. But to kickstart us off, I wanted to introduce our small business and inventor hub, which was just launched recently in the past month. This hub is dedicated and aimed to guiding innovators, entrepreneurs, and small businesses through the process of protecting their intellectual property using transparent pricing for tailored services. It provides a comprehensive patent and trademark assistance to clients, including free resources, FAQs, custom service packages, and even more. It's an easy point of entry for our clients, and clients are moved smoothly through the patent and trademark application process. You can access it here on the link. This will be clickable, and then we will also be sending it out and putting it in the chat as well. This is a great opportunity for us. We're extremely excited. And with me to talk about trademarks today is DBL partner Alex Butterman. Alex's practice covers all facets of trademark prosecution and practice before the U.S. Patent and Trademark Office, which also is known as the USPTO, and virtually every trademark office around the world with the help of an extensive network of foreign associates. Alex has also been counseling a diverse group of foreign and domestic businesses in a variety of industries and commercial sectors since 1995 at all stages of development, assessing and searching the ability of marks, establishing and enforcing and maintaining trademarks and in-service marks rights, resolving intellectual property disputes, handling internet domain IP issues, anti-counterfeiting matters, copyright prosecution, IP licensing, and transactional matters, and intellectual property research and due diligence investigations. Alex has also served as an attorney advisor in law for the USPTO trademark examining operations for 3 years, where he examined thousands of trademark applications. Alex was also recently recognized in the WTR 1000 for the year of 2024, which is an amazing recognition. So without further ado, here is Alex, and I'll stop sharing my screen so we can get started with this Q&A. So first off, Alex, thank you for joining us.
Thank you for
Um,
having me.
so what the topic we're here to discuss, what is a trademark and why is it important to have one?
Sure. So a trademark, according to our trademark statute, the Lanham Act, is any word, phrase, symbol, or design or a combination thereof. So basically, it's any word, design, symbol, anything that basically can represent what your business is and identify for consumers that the products or services you're offering are from your business. So it's basically just has to be something distinctive. Um, that people can recognize right away, uniquely points to you. It doesn't refer to something else. It's basically trademark is basically a legal term for a brand. It represents the goodwill of your business. It's a legal concept for the goodwill of your business.
So it's extremely important to have one then if you're trying to brand and be differential.
Yes, and actually, really every business has one. It's more what we're talking about more importantly is probably how to protect it and make sure that you recognize that it is your brand and that you want to protect it the right way and you're not infringing on anybody else's brand.
Absolutely. And how do trademarks differ from copyrights and patents? I know we hear these terms a lot, so what's the difference?
Sure. So these are different forms of intellectual property that protect what's our products of the mind. They have different mechanisms, different purposes. So a copyright is really for artists, creatives. It protects any form of expression that's in a tangible medium, as the statute describes it. So basically, writings that are reduced, to paper or nowadays, I guess, saved in a computer, or the writing of a song. It could be the performance of a song. It could be a video. It could be any artwork, photography, two-dimensional, three-dimensional. All these physical expressions of art, that copyright protects that and prevents someone from copying it exactly. A patent is a little broader. It protects basically an idea that can be reduced to practice or a design that's a product design. It's basically you get a monopoly on that particular invention is what you usually refer to that it protects. You get a monopoly on that for about 20 years, but you have to describe exactly how it works and then that's it. That's all you get. But the trade-off supposedly is the monopoly for 20 years in exchange for letting the world know how you do it.
So essentially, all these things fall under the IP realm, and they can work in tandem, essentially.
Sure, sure.
And then what are the different types of trademarks? I know we hear multiple different things.
Yeah, so I guess there's different types. There's different types of trademarks in form, like whether it's a word, a design, a slogan, a whole logo combining the slogan, the word, the image. There's also some sort of functional types of trademarks, like a service mark for services. Trademark is really for goods, although we use trademarks to refer to everything. There's certification marks that the business can own, but it allows others to use that mark, and those others have to satisfy certain standards. So the certification mark certifies that a business has met certain standards, certain
Mhm.
qualifications. A collective membership mark is similar, but it represents that the users are part of a certain group. Like a lot of times, clubs will have collective membership marks, and the emblem they wear on their jacket to show they're a
Okay.
member. That's a collective membership mark. Um, so that's, I guess, a couple of ways, couple of different types of trademarks that we refer to.
It's a whole different world, multiple different things that you can do. That's
Sure.
awesome. So, is a trademark search really necessary? I know you mentioned it a little bit earlier. Is it something that's necessary? And how can one perform the trademark search to ensure that their mark's unique and available?
Yeah, it's a good question. Actually, I would consider the trademark search the most important aspect of all this. It's even more important than registering a mark because, like I said before, every business has a mark. Trademark rights are actually created by just using the mark, just by putting the mark on a product and selling it in commerce, or advertising the mark, advertising your service with the mark. That is actually using a trademark in commerce, and that gives you rights in the trademark even before registration. But what's more important is that you don't want to start actually acquiring those rights when those rights actually belong to somebody else. So it's really important to search the market, the relevant market, well, actually the whole U.S. market, and make sure no one else is out there in your field using any similar mark. Um, and the ways to do, well, the obvious way, I guess, and most straightforward is you search what's on file in the U.S. Patent and Trademark Office, which
Hmm.
is, applications for registrations or registrations, and there's a few million of those. But actually, like I said, you don't need to register a mark to use a mark in the US, and you get rights without the registration. So you need to also search what's not registered. And I think the best way to do that these days is just an internet search, because I don't know many businesses these days that are not on the internet.
Yeah.
Um, so, that's the easiest. I mean, I would say you don't necessarily need an attorney to go onto internet searching to see if there's some business out there that's closely named to your business, but where the attorney is important is in interpreting the search results, because um, infringement and confusing similarity does not require that the marks are identical or that the products and services are identical. They can just be similar and lead to consumers to believe that the same business using similar marks creates, is behind both. That would be infringement, confusing similarity. Um, that's why I say searching is very important, even if you don't, decide to register right away.
Yeah. So essentially, a lawyer's there to help interpret, though, if you're not really sure, especially because of the fine line of not knowing if it'll be recognizable and confused for infringement.
Right, right. Because there's that gray area. A lot of times, you're not going to. I think people know not to use the exact same mark as somebody else, but a
Yeah.
lot of people say, "Well, can I use this? Can I use ABCD instead of ABC?" And that gets a little fuzzier. And we have a lot of experience. We see a lot of these different comparisons, and while we can't, predict the future, we can kind of have a sense maybe of,
Of protection, essentially,
yeah, what
going
might
down the
happen or
right
not.
path.
Or you can at least we assess the risk better because we've seen a lot of these cases.
Yeah, no, definitely. It's
And that's what
extremely
the search
important.
does. The search really is it assesses risk, and it actually assesses the risk of a mark not only infringing another or someone else infringing you, but it also assesses the distinctiveness of the mark, how protectable it may be, and some other issues that may arise in the examination.
So extremely important in the process of getting your trademark registered, making sure you do the search is step one, essentially.
Yes, yes, definitely.
Awesome. So now that we've done step one, which is searching, what does the process for registering a trademark look like? And can I establish a trademark right without registering my mark? I know you kind of touched on that earlier.
Sure, sure, yeah. So as I mentioned, once you start using the mark on in your business, you've got to actually be operating the business. So there's got to be sales or services being rendered, and the mark displayed and all that. Once you've got that going, you actually are acquiring rights. But registration is obviously very important and what everyone thinks of, because for one, the right to acquire when you don't register a mark is just where you're actually using the mark. So, that might just be in your local metropolitan area, or wherever the internet website reaches people, which, well, that's basically the limitations of an unregistered mark. But a registered mark will give you nationwide rights once it's registered, and also certain presumptions in court that make proving your rights in the mark a little easier. Those are a couple of the biggest advantages. And of course, it lets everyone know that you um, own this mark, and you have a little formal certificate that says it's registered that you can show to anyone else that might be using them or thinking of using your mark. So there's a good deterrent effect too, and it also the U.S. Patent and Trademark Office, when they examine the marks, they'll see your registered mark. If someone else tries to register your mark, mark or something similar, they're going to not allow that. So there's a very important benefit to registration. So what do you do to start the process? Well, basically, you just fill out a form that's now online that is going to ask the specifics of your business, the legal name and entity, where
Mhm.
obviously you have to show the exact mark that you want to register, and the process is very specific to that. If it's a design, you have to show the exact design you're using. If it varies, it's not going to be the registration is not going to be granted, or the registration is not going to protect um, the mark that's actually being used. Um, you have to list the goods or services that the mark is used with, because by definition, a trademark only is giving you a right, an exclusive right in association with the particular product or service you're offering, the particular segment of commerce that you are doing. It doesn't give you
Mhm.
rights to, that mark everywhere.
Okay.
Um, so the trademark application is going to require basically that parameter, that boundary, describing what the goods or services are. And then the examiners actually examine the application for a number of substantive and procedural criteria. One of them is what we talked about whether or not it's infringing another mark. Basically, the examiner searches only the records of the U.S. Patent and Trademark Office, its applications and registrations, to see if there's a mark that's similar. And if there is an existing similar mark, they're going to refuse to register the mark. They'll also search for the distinctiveness of the mark, meaning how well the mark functions as identifying the source of the product or services, which we might get into later. And examines, it's going to examine that the mark is properly being used in commerce. There's a lot of,
Okay.
one of the more difficult areas of registering a mark is technicalities, the technicalities of how to use a mark according to the law. The law has been sort of rigid like that. And in terms of, and when I say use, I mean like how you apply the mark to the products or services, so that
Mhm.
consumers can look at it and say, oh yeah, that's a brand. That's not a information about the product.
Yeah.
Um, Things like that. And then when all is said and done, the USPTO will issue the formal registration certificate, and you get your registration.
That's awesome. So essentially, backing up a little, the search is really important because if they find something during the examiners find something where somebody else currently has that, then you're back to square one, essentially.
Yes, good point. Yes. So obviously, right. So when you apply for the mark, presumably you will have done a search and you'll have seen that there's no other similar mark out there, especially in the trademark office. Because if you do, then you can kind of get a sense that, oh, the examiner is going to find this mark and they're going to reject my application. You might also see applications or registrations that were, let's say the mark is similar sort of in the meaning, or you obviously if you obviously you'll see marks that are in your field unless you're a totally brand new product that's never been out there. So if you see like another widget like yours, and then you see the name is similar, you might be able to see how that examination went with that name, and you might see if the examiner said, "Oh, that means actually you're actually describing the product, so we can't register the mark." So we pick up on issues like that too with the search. So the search really is a great assessment of risk in terms of not just how using the mark will work, but also how registration will go.
Awesome. So very important. Do your search. Now, we've talked about the USPTO, and I know you've assisted with them previously. Can you explain what those string of words mean?
U.S. Patent and Trademark Office.
Okay.
So basically, it's a federal agency that is part of the Department of Commerce under the Secretary of Commerce. And I guess the way historically has been set up is that patents and trademarks have always been examined in that same agency, although they're not examined by the same people. They're pretty different sides of the agency. And then copyrights are examined by a part of the Library of Congress, so that's separate. Um,
Okay,
but
so they're the deciding factor whether or not your trademark or patent gets registered.
Well, I should clarify. That's a good point. That I should clarify. They're initially the deciding factor, but
Okay.
once you apply for the mark and the examiner approves your application and says, okay, this is good to be registered, it's going to get published in what we call the official gazette. It used to be a printed publication that only lawyers read. Now it's
Mhm.
basically part of the U.S. Patent and Trademark Office database. But the significance of that is that it starts a 30-day period, 30-day window when anyone out there who thinks they might be damaged by your mark registering, usually a competitor,
Mhm.
can oppose your application. So we actually have a second phase to the examination process. There's first the examiners at the USPTO examine for the particular rules and requirements set forth in the U.S. Trademark Rules of Practice, and um, then you've got anyone in the public basically who can say, I don't want this mark to register because it's too similar to mine. And then then they can start what's called an opposition proceeding, which is sort of like it's an administrative litigation within the trademark office at at a forum called the Trademark Trial Appeal Board. Um,
Okay.
and so if that opposer prevails and proves that there's grounds not to register your mark, usually because it's similar to theirs, it could be other grounds like that it's descriptive. Um, then that would prevent the registration of your mark as well. And I should mention that in that same forum, registrations can also be canceled even after they're issued for up to the first 5 years after they're issued, basically on the same grounds that they could be opposed.
Okay. So let's say everything went smoothly. We were all good, nobody opposed it, they approved it. How long does the registration last, and can it be renewed?
Sure. So yeah, so registration is granted for 10-year period,
Okay.
10 years from the registration date, but at the between the fifth and sixth anniversary of the registration date, you need to submit a declaration and evidence that the mark is still being used. So
Okay.
we mentioned that rights in a mark in the US are created by the actual use of the mark. And that holds true through the registration. The registration is really just an enhancement of those rights you get from using the mark by making those rights nationwide. But you have to always have that use of the mark. You cannot, registration is never a piece of paper that you can assert and gives you the right without the actual use of the mark. So there has to be the ongoing use in a proper manner, in a manner that it's in commerce, uh, showing that it's your mark uniquely, um, a regular. It's got to be regularly. I mean, well, it's got to be consistently and continuously used. Um,
Hmm.
so so um, you can lose a registration for not using a mark. If you stop using a mark for a period of 3 years, it's presumed that you've abandoned your mark, and that can be confirmed, and it can be determined that you abandoned your mark if you have 3 years of non-use plus the lack of intent to resume use. There are other ways to lose a mark, such as if the mark it becomes generic, with what we call genericide. You know, it's if you can if you so if you use a mark, if you make a product, create a product that's never been on the market before, which probably is the case for a lot of people here for inventors, you're inventing a product that's never been out there, and you give your product a name, a mark, and everyone refers to that product as that mark. Everyone refers to that product by using that mark. If there's no other way to refer to that product, because everyone's going to need a way to refer to the product if it's never been out there, right? You have to basically, when you have a new product like that or service, you have to think of not only a brand for that product, but you have to think of a generic or a descriptive way to describe that product, because otherwise people are going to turn your brand into the way to describe the product, much like people almost did with Xerox, and calling photocopies Xeroxes, or these days I think people almost do that with Google. Google was challenged and almost lost their mark like that. Same with Windows. You have to have a descriptive way to describe your product, and use your mark as an adjective describing that term that you create. Like, I mean, one of the famous marks that it became generic that was a mark was escalator. Escalator is generically described as a moving stairway. It should have been escalator brand moving stairway, and they might still have the mark. Instead, everyone calls it an escalator. That's so that's more of a legal determination of how you lose your mark. It's not administrative, like you don't file the renewal. But it's important to keep that in mind, that is also a mark. You do have to kind of use the mark and earn the rights to keep the rights.
So it's very strategic planning when you're coming up with your marks and stuff like that and your branding.
Yeah, it's another good reason to kind of work with a lawyer and all this.
No, definitely. I mean, I wouldn't know any of this unless I wasn't speaking with you and using you. So I know a lot of times we see the little TM or like the little R with a circle. Can you explain the difference between those two symbols?
Yeah, sure. So the R in a circle, that's what we call it, which everyone knows. It's basically a capital R with a circle around it, and it's usually superscripted. That refers specifically to a granted registration. So you're only supposed to use that by the mark that actually has been registered by the U.S. Patent and Trademark Office. You have the registration certificate. It's got a registration number. Every other kind of mark, basically anything else you want to think of as a mark, you just use TM or SM. SM for service mark, TM for trademark, and usually that's superscripted. And all that basically means is that you're claiming that it is your mark. You're expecting you have rights in that mark. A lot of times the people do that when they're applying for the registration, but it's not yet granted. So the TM is basically you put it by anything you think should be your mark. You're claiming rights as your mark, and then R circle is what you use to say that it's registered.
So to differentiate, essentially, that
Yeah,
this
you're
is
not supposed to, obviously, you're not supposed to use the honor circle if it's not registered, and technically that could be considered fraud.
Oh, so don't use it unless you know it's registered.
Right, you have the actual registration certificate or registration number.
Awesome. Well, what are some common mistakes to avoid during the trademark application process, other than not using the R if you don't have it?
Well, the first I would say is doing the search. Not searching could be a mistake because for a lot of reasons. I mean, usually, the biggest reason is you're just going to get blindsided somewhere along the way. You don't know if you don't know who's out there. And I mean, a lot of clients will tell me, "Oh, I know I'm the only product out there. I've never seen this before. I know that this market is available." And then, several years down the road, there is someone who comes out of the woodwork and says, "Oh no, I've been using this, and um, and you're infringing me, so you have to stop using the mark." And a lot of times, actually, the way this is coming about is when businesses don't register the mark for a while, and then they decide later on that they want to get the mark registered,
Mm.
and then they realize someone else has already registered the mark, even though they might have been the first user, and then the trademark office reviews their application over the later user and earlier registrant, and then they have to basically go back to that earlier registrant and say, hey, I have rights in this mark that I had before you, and you therefore forced to stop using it. And now, I mean, how could that later registrant have seen that and avoided that? Well, if they did a trademark search and they properly searched not just what is registered, but what is not registered, then in theory, they should have been able to see that other not unregistered user.
Hmm.
So that's I would, anyways, we've covered the importance of searching. Another important uh, another thing that's important is to select a distinctive mark.
Hmm.
So there's actually a whole spectrum of distinctiveness when it comes to marks. The spectrum is, on one end, there's generic marks, which, was like an apple for an apple. You just describe
Yeah.
exactly what the product is, and no way to claim rights in what a product is, which is the English language says is what it is. That's one end of the spectrum. The other end of the spectrum is what we call a fanciful mark. It's a totally made up word applied to a product and has no other meaning than what is that product. Like, and the typical example people use is like Kodak film, and I don't even know if people know what Kodak film is anymore these days, but
I'm familiar with it.
okay. But we're a dying breed. So,
Okay.
well, anyways, Kodak did a lot with photography, and that was a made up word, and people would know that word only as representing that company.
Hmm.
In between are uh, there's all different levels in between. So right before fanciful, but also very strong, is what we call arbitrary.
Okay.
Arbitrary is taking a regular English word and using it in a totally new meaning, like Apple for computers is a
Yeah.
classic example. So on the strongest end of the spectrum of marks is arbitrary and fanciful. Those are the kind of marks you really want to create and protect, because those are going to be the most protectable. They really have no meaning except what you tell it the public
Hmm.
is referring to your product. Towards the generic, but not all the way, are what we call descriptive and suggestive marks. Descriptive would be like if you have a scented candle and you call it chocolate. You're describing the
Okay.
flavor. So it, that's it, maybe that will become protectable after 5 years or more of use in the market,
Hmm.
and then the consumers learn that chocolate scented candle is your specific chocolate scented candle, or um, American Airlines, as I guess would be another example. With everyone right away will think, oh, American Airlines is just describing an airline that's from the U.S.
Yeah.
But I mean, now everyone knows it as specifically American Airlines because it's been around for years, and so that's a descriptive mark that it not necessarily protectable in the beginning, but after a while, with a lot of exclusive use, it can be. And then in between that descriptive and the arbitrary is what we call suggestive marks, and that's like a real hybrid. And an example would be like Burger King. Burger King, obviously, the burger describes, that it makes burgers, but
Hmm.
King doesn't really describe anything. So the combination, um, it sort of hints at that, we call it an implication, or it's hinting at what the products or services are. It's not really telling you what the products or services are. That's what we call suggestive, and those are what we call inherently distinctive, or marks that are protectable off the bat. But there's really a big gray area between what's descriptive and what's suggestive, as you might imagine. Um, so in terms of best practices, I mean, ideally you want to pick a mark that's in the arbitrary, fanciful end. But I've heard a lot of clients tell me, well, I don't want to pick a mark that people don't know right away what the product or service is. They want their mark to tell what consumers what the product or service is, which is
Absolutely.
kind of getting to the descriptive generic end, and not necessarily the best legal strategy, but it also, from their business standpoint, is more economical, because they don't have to spend a lot of advertising dollars to teach the public that their mark is what their goods and services are. So that's why a lot
Mhm.
of, I guess, a lot of smaller businesses or newer businesses will prefer the suggestive mark that kind of hints at the business, but doesn't, but it's still protectable because it's not telling you everything about what the business is. Um, so that's I guess one of the sort of the best practices, I guess, for
Mhm.
selecting a mark.
So
Um,
definitely being strategic in what you pick and how descriptive it is and stuff like that. And then also doing your searching to make sure it's not too generic where other people are currently using it and stuff like that.
that's correct, and that again is what is visible in a search because you see all these different marks for your industry probably or possibly, and and you can see what you just see how these marks are examined when you see the search results, and you get a sense of what the trademark office considers descriptive, what they
Hmm.
consider, um, what it does get through is registration. That is another way the search helps.
It's always back to the search. So, how can a trademark be registered and protected internationally? Say I want to do that.
Sure. So it's important to know that trademark rights are territorial. They only extend to the country that you're using it in or that's granting them. There's no such thing as an international trademark. Your U.S. trademark registration is not going to be valid in any other country by, by the fact that you have the registration from the U.S. And so you have to actually register the mark in each country that you want to get your rights protected there. Sometimes a country will allow you to protect your rights if you just use the mark, sort of like the U.S. But more often than not, you need to actually register the mark. And actually, most countries, the registration is what creates the right, not the use. They don't even necessarily recognize the use of a mark without registration. Um, so you register a mark by applying directly to the trademark office of the other country, and we work with associates, lawyers in other countries that help us with that. There are some jurisdictions like EU where you actually can, protect all of EU countries in one registration.
Okay.
And people, you might hear the term international registration used as a legal term. And there
Hmm.
is such something called an international registration, which is a registration through the World Intellectual Property Office, which is a non-governmental organization in Switzerland. But that's not really international registration. What that is a cluster of national registrations filed all
Gotcha.
together through that international office we call WIPO.
Hmm.
And then they'll the so basically each country that you designate in that application will separately examine your application just as if you apply directly, but you basically get one certificate that says this mark is registered in all these countries because it's been examined in all these countries. And that's the technical meaning of what is an international registration, but it's not really international. Basically,
Okay.
yeah, you
It's
have to.
based on the countries or wherever that you decided when you're applying in that one-stop shop essentially application.
Well, if it's one-stop shop, if in terms of procedurally through WIPO, but
Yeah,
it's not one. But
procedurally.
there's no. And the EU, if you like file in the EU, you get the registration covering those 27 countries. But otherwise, you do basically have to go to each country and separately apply to register.
If not doing through that one application through WIPO, correct?
Right, right.
Yeah.
So there's a lot of cost benefit analysis and strategies that to consider with that.
Awesome. I had no idea you could even do that. That's very neat. Um, Moving on. So I know we've talked about a lot about trademarks and stuff like that and the importance of going through the right channels and doing the searches, but how can I enforce my trademark rights as a business?
Sure. So obviously, once a part of maintaining a registration or a mark and not losing it is making sure that you protect it and make sure that you're the only business in your field that's using that mark or anything close to it. So you have to obviously be aware of the market, monitor either what's being filed in the U.S. Patent and Trademark Office, or maybe do regular Google searches or other internet searches to see that, if any business is starting up that uses a mark that's similar. And then we have, I guess, just sort of a gradual process of how you want to enforce your rights. I mean, obviously there's the lawsuit and suing, a company to say you can't use that mark because I have it registered, I'm using it. But before we get to that, usually there's going to be a letter sent or some communication, and hopefully the other business responds to that and is responsible and will realize, okay, we'll stop using the mark. And
Mhm.
that's the first step. Nowadays, with a lot of businesses being online, another step is just simply requesting a takedown of the mark on the website where it is, if it's Facebook or if it's Amazon. These sites, they recognize there are trademark rights. They say in their terms of use, you can't violate someone else's trademark rights. You have to be able to prove to them that you own the trademark right, and that usually is requiring a federal registration. So if you don't have the federal registration, I think you might have a little difficulty with that.
Okay.
It's another value of the registration these days. Um, and then if the mark that you see might be infringing you is applying to be registered, another enforcement mechanism is, as we talked about before, you oppose the application, say
Yeah.
you can't register it because it's my mark, or if it's registered already, you can file to cancel the registration, showing that you had the earlier rights. That's it's litigation, but it's more streamlined, less costly for the most part.
Mhm.
Um, but it only works for taking away registration. It doesn't stop the use of that mark. So the only way to stop someone else from using your mark is to go to court, you get the injunction, or the judgment that they can't use the mark and there's damages, which is obviously a long, difficult process. But more often than not, once the communication is established and the parties realize that maybe someone has used it before they did,
Mhm.
it'll be worked out that the infringing use stops. A lot of times the trade-off is that the plaintiff, the mark owner that's enforcing, they agree to allow the defendant to have a phase out period of um, that mark that they were using improperly, and
Okay.
that usually at least they get the mark off the market that was infringing, but they do have to tolerate that they let the other party, use up their packaging or whatever.
Okay. So essentially, if someone's infringing my trademark and my rights and stuff like that for my mark, there's little steps to be taken. There's nothing, you're not going to go to the extreme and go dispute it and stuff like that, infringement. You're going to ask them essentially through a letter, like you mentioned.
Right, right. Again, that's a lot of what we do as lawyers, and people may try to do that initially. They usually end up needing to come to a lawyer just because lawyer to lawyer, we kind of speak the same language. There's
Yeah.
more people will take us more seriously, take the whole situation more seriously with the lawyers. So,
Good. So it's important to have it registered and make sure you're doing your searches and stuff like that. So I know we've talked a lot about everything encompassing trademarks. Now, can we jump into some examples of successful trademark strategies by some well-known brands so that our audience members can kind of understand like what they did well and everything that we've talked about?
sure. One sort of famous strategy is what we call a family of marks, and the famous example is McDonald's, where you've got the little Mc prefix before everything. So, I mean, remember, the whole point of a trademark is that it's identifying the source of the product or service. It's basically an announcement to everybody. This is, this my business's product. and anything you can do to reinforce that source is better. So if you have a bunch of marks with the same sort of prefix, then everyone starts to understand, oh, that Mick is going to be that restaurant.
Hmm.
There was, there used to be a famous toy store, Toys R Us, that had that concept with the R Us suffix. Um,
Yeah.
that's one sort of strategy. Another is being more creative with your mark and not necessarily using a word or a design, but using trade dress. A typical example is like the brown and silver color of the Hershey's packaging.
Mm.
I've seen it like these sort of displays, exhibits where someone would they would print like another name in the brown and silver, font and coloring of the package of a Hershey bar. And
Hmm.
right away, people would look at it and they would see the Hershey bar source. They would think of it as Hershey, and not whatever the name was on it.
Mm. I think
So
of Hershey and not what they were trying to
right, and we call that
display.
trade dress, and it's a more difficult form of mark to protect because it really is not inherently distinctive. People don't right away look at these colors or designs and think, oh, that's going to be telling me that's a certain company or that's a certain, they're going to think it's a nice color. But until they actually see it for a while and they see all the time this one product and this one sort of pattern, then they're going
Hmm.
to establish, oh, that is this product's coloring, this product's pattern. I think T-Mobile's done it with their magenta color, and
Yeah.
there's the orange coloring of U-Haul. Those are some examples. Or brown
Coke
with
and
UPS.
Pepsi.
Yeah, yeah. Coke actually a good example. They had the bottle, the classic, Kirby bottle that goes back 100 years or so. That's one of the first forms of trade dress. Um, I mean, these are obviously more difficult marks to. I mean, because you have to invest in the whole, design and creation of the design. Um, but those are some examples of a strategy to create a trademark portfolio.
So a lot of
Um,
it really has to do with branding and marketing and thinking of how you want to be perceived from your consumers. And then once you have that idea, then it's the right thing to do is do your search, get with an attorney to figure out what's next steps need to be taken to go through your registration process.
right, right. Everything in trademark law actually is what is in the perspective of the consumer, what is how consumers view, the product. Really, trademark law is all about consumer protection. It's not necessarily a property right designed for the business owner, although it is that. It's really a consumer protection mechanism to help consumers distinguish one product from another. And so everything in trademark law really comes down to how consumers are likely to perceive the mark. If you're looking at the similarity of marks and whether they're too similar, it's the ultimate analysis is going to be, well, what do consumers think? Are they going to look at these two marks and two products and say these come from the same company or not? Are they, or is this mark identifying what the product is, or is this mark just describing what the product is? That's, what are consumers going to see? It's all about how consumers are going to view that mark that really determines how the legal outcome. And in that sense, the most direct evidence in trademark law is usually consumer surveys.
Mm. Awesome. So those are all my questions. Now I'm opening the floor to the audience. If you guys have any questions, please feel free to put them in the chat or go ahead and unmute yourself and speak up. This is your opportunity to ask Alex anything that's on your mind, any questions you had about our discussion and the questions I had. It's a great opportunity. Um, now's your chance. But before any of that, while you guys are typing your questions or thinking about them, I wanted to reiterate, if you do have a trademark that you need registered or you have a patent or an idea or anything like that, please use our new Inventor Hub. It is a great tool for you. We have a lot of FAQs on there, a lot of resources for you, all free. If you have any questions or anything like that, please reach out to us as well. Does anybody have any questions for us? If not, then we will go ahead and conclude today's webinar. Oh, we have somebody typing. Can you seal a trademark?
Meaning make it confidential? Is that
Sell, typo.
oh so good question. The US again is very strict about tying the trademark to the goodwill of the business and then making it identify a business. So you cannot sell a trademark apart from the business. So if you're going to sell a trademark, you have to sell the whole business it covers with it. And actually, if you try to sell a mark without the business, the underlying business, you invalidate the mark, and you can have the registration canceled. That's another way actually a mark can be lost.
Essentially, either it's a package deal or not at all.
Right. Now, I mean, there are people who sell registrations, and maybe they're and really what they're buying is the basically the streamlined process of
Mhm.
not getting opposed or not getting rejected at the trademark office because there's an early registration. So they just want to basically acquire that early registration, and maybe that registration isn't valid because it was not being used, but the purchaser might basically out of convenience be paying a certain amount to the prior owner just to kind of get the owner to give up on paper the right that they had in the trademark office. But really, the actual purposes of a trademark, there's got to be the underlying business with it.
Okay. I hope that answered your question, Jim. Does anybody else have any questions for Alex before we conclude today's webinar? If not, this webinar was recorded and we will be sending it out along with the rest of our webinar series. If you haven't already, please sign up for the other ones if you have any additional questions. This was just an overarching one about trademarks. We'll dive into different aspects of different topics that we discussed today in more in depth. So if you have questions, please join our other webinars. And feel free to reach out to Alex. I'll be also including his contact information as well, along with the link to our hub should you have any other questions or would like to use our resources. Once again, thank you, Alex, for joining us today and answering all my million and one questions. You
Thank you
did
for
a
having
great
me.
job.
I'm on the
Um,
website. You can see my bio on the website and my email. So
Absolutely. I feel like I learned so much. I feel like I'm an expert now myself, but I still
great.
would need your help.
My
All right,
pleasure.
everyone. Well, thank you for joining us. This will conclude our webinar.